Hello, friends. I hope all of you are in the best of your health and spirits and are curious to learn more as always. Through this series of videos, we shall discuss some of the questions that were posted on my Telegram channel. Those who are not aware may see the link in the description of this video below. So, the plan is to learn and revise some basic knowledge of Indian polity through these multiple choice questions, as well as to learn how to go about preparing and appearing in the UPSC civil service exam, the preliminary exam, especially at this stage. My belief is that if you can revise through these 500 or so questions that I'm going to put up, it shall serve a good purpose in your preparation for the exam, as well as in the overall learning of the subject. I will take you through the questions one by one, and I suggest you pause the video at each question and mark your own answer first before listening further. This will help you not only know what is the right answer, but also to refine and sharpen your understanding, and also to improve the ability to mark the correct answer in the exam. These videos are very short. I've taken 10 questions at a time so that it doesn't need too much of your attention span. So you can even binge watch if you feel like. I've also added some additional information in each of the slides, which I believe will add value in your overall preparation. They may not be even related to polity, but they're related to your general awareness. I will highlight as we go along, but sometimes I may not. So there is a lot for you to explore yourself as well. So do follow the slides carefully, and please keep the Constitution of India handy, either your book or your mobile app. We will be referring to it often. All right, so let us begin. The first question that was posted on the channel was this: which of the following are federal features of the Constitution of India? Now see, let's also try and learn through these questions how to attempt and how to ensure you don't mark it wrong, especially when you know the answer. Now this question is actually a very basic, a very conceptual question, not that difficult. There are two parts to this. One, that which of the following, the five sentences there, they are federal features and in the Constitution of India. So both of these have to be correct. See, it is totally possible that something is federal feature but is not part of the Constitution of India. Or the other way around as well, that something is in the Constitution of India but actually is not a federal feature. So both of these ideas we have to check for each of these five options given to us. Now let us see the first option, the division of power. I'm sure we all easily will agree that it is a federal feature. Because whenever you have a center and state relationship, or federation and federating units or provinces, there must be clear-cut division of power, the way it is done in the Constitution of India. Very simple example, we know the 7th schedule clearly defines the subjects for each of them. Then the second option, the separation of power, which essentially means the separation of powers of a government, that is the legislature, the executive and the judiciary. This is definitely present in the Constitution of India. We know that. However, this is not an essential defining feature for being federal. It can be there in unitary as well. It may not be there in some federal countries. It's more of a modern state governance principle that is followed. So coming to the third option, the single constitution for union and state. Now, when you have a single constitution, of course, the identity of the state is not at the same level as the union. So in the truest sense of being a federation, as it started in the United States of America, the center and the states, they have their own constitutions. So it is not a federal feature. However, this is definitely a characteristic in the Indian Constitution. Now, when you have the states, of course, there has to be a council of states, a house of states, a Rajya Sabha, a Senate like in the US. So that is a necessity of being federal, and that is definitely present in the Indian Constitution as well. And of course, when you have two entities, like the two kids of a family, they will definitely have their issues, their differences of interpretations, disputes between center and state, and to ensure that is resolved amicably, there must be an independent judiciary. So it is a necessary feature for being federal, and it is part of the Indian Constitution. So as you can see, out of the 5 options given, except these 2, that is option 2 and option 3. The only correct options are for us 1, 4 and 5. Now, it was not that difficult question, but still, if you see the performance, it's hardly 1/3 of the respondents got the correct answer. That is around 8,500 odd people had attempted this question. So that's not that good performance as such. Also on the right hand side, you might be able to see this is the US Capitol. That is the seat for the US Congress, the House of Representatives and the US Senate. So I thought you should have a look at that. In reality, it looks something like this. Anyway, moving on to question number 2. Which of the following statements is or are not? Mind the word not. These are areas where people make mistakes when they read the question too fast, which are not correct regarding the preamble of the Constitution of India. Now, the first statement itself, that it is a limitation on the powers of the government. It is not a limitation. There is no express limitation mentioned there. And this was a very clear judgment that has been provided in the reference Berubari Union case, that there is no direct limitation on the powers of the government. In fact, this was the whole argument based on which in Berubari case, the Supreme Court held that preamble is not a part of the Constitution, which was of course overruled in Keshwananda Bharati case, which declared that it is a part of the Constitution. So even the second statement is wrong along with the first one. It is a part of the Constitution. Now, is it part of the basic structure of the Constitution? No. It is not a part of the basic structure. However, the confusion remains because I understand some of the words, the ideals mentioned in the preamble, they have been declared as the basic features of the Constitution. For example, secularism. Now that is a basic feature of the Constitution. So anyway, all three statements are wrong, and the performance again very poor as such. Hardly 28% got this correct. And on the right, that is the actual picture from the Constitution of India. Moving on, question number 3. Which of the following statements is correct regarding the Constitution of India? So only one of these can be correct. Now this is, I think, somehow the worst performance displayed by the users there. Hardly 8% got this correct, which is actually very poor from any standard. I know most of the confusion has been with option A, but that's the purpose of this question. It says it was enacted on 26th January 1950. No, it was not enacted on 26th January. It was enacted in 26th November 1949 itself. It was enforced, and that too only some of the provisions. Large part of the provisions actually, but many of the provisions got enforced also on 26th November 1949 itself. In fact, later we will see that the preamble very clearly does this, give this information that when it was enacted. Then regarding the second statement, that it repeals Government of India Acts 1919 and 1935, I will show you a document quickly. So that's the actual Constitution of India. I took a picture from that. So if you see Article 395 in your Constitution as well, it very clearly says that the Indian Independence Act 1947 and the Government of India Act 1935 are hereby repealed. So the Government of India Act 1919 was overruled by Government of India Act 1935 itself. And it was the 1947 Independence Act and the 1935 Government of India Act that was overruled. Also, as I told you, the preamble, if you read the last few words, it very clearly says that we, the people of India, hereby adopt, enact, and give to ourselves this Constitution. Anyway, coming back to the question. The second statement is also wrong. Now, the third statement was the original Constitution is handwritten in Urdu, Hindi, and English. Now, one important word here is handwritten. Yes, it is handwritten. In fact, you should know that it was Mr. Prem Bihari Narayan Raizada who has handwritten it in a flowing italic style. So if you remember what I showed you, this is all written in italic style by Mr. Raizada. But there was no Urdu version of it. There was only Hindi and English version which was created. There were just 2 copies. I would sincerely request that when you have some time, if you have interest, if free time, let's say after mains, you should sometime go and see the actual constitution, the way it has been written down word by word and decorated. So it's available. The scanned version, of course, is available on the World Digital Library, WDL. You can Google and find out. And the actual copies are in the Library of Parliament in cases filled with helium. So if you ever visit the Parliament, go to the library and see what the actual Constitution of India looks like. Now the decoration, as you can see, all these nice decorative pieces, these were done by many artists from Shantiniketan. And 2 names are especially always written, so you should know, Beohar Ram Manohar Sinha and Nandlal Bose. Now, the only correct statement here is the 4th one, which a lot of you actually marked wrong, that the original constitution had 29 states in the first schedule. I understand that large part of the confusion has been because of this number 29. Also because some of the books that you read, they may not have got the actual numbers, or some confusion is there. I really don't know. But never be confused. As I told you, you can go in the on the World Digital Library and see the actual constitution. Go to the first schedule and see that the first schedule has been divided into 3 parts. Part A, Part B, Part C, and Part D. These were the 4 categories of states. Part A had 9 states. Part B also had 9 states. Part C had 10 states. Excuse me. And Part D had just 1 state, the Andaman and Nicobar Islands. So that all makes it to 29. So never be confused in this area. There were actually 29 states, though when we started after independence, it was close to 600 princely states and provinces. But gradually, as the constitution came to being, it all was made to 29 states. So that was question number 3. Moving on to question number 4. To uphold and protect the sovereignty, unity, and integrity of India is a provision made in. Now, this is actually a straightforward question. This is just a statement from the Constitution. So I thought it was a decently, simple question. But if you see the performance, again, less than half of the respondents only could get it right. I don't really think there's much explanation required here, because this is actually a fundamental duty. This is the 3rd duty under Article 51A, Clause C of the Constitution of India. I would sincerely recommend and request and urge you to read the duties as citizens, as future civil servants, great people of India. There are just 11 duties that you should be aware anyway. Also for the exam, do read it a couple of times. This is always a talk of the town, and UPSC loves to ask you something around the duties, and mostly they are straightforward questions. So anyway, moving on, question number 5. Which of the following articles of the Constitution of India confers the power to state to acquire a foreign territory as well as to cede national territory in favor of foreign state? So it says power of the state to acquire and to cede our territory, that is exchange of territory. Now, this is actually a question which I would say is a good question. Now, I believe that none of you should be confused in option 1, because option 1 has nothing to do with acquisition or cession of any territory. It just defines what is India, what is territory of India, which are the states. Also, Article 3 deals with just the reorganization, changing of boundaries, names, and such kind of things. Jammu and Kashmir or Telangana, these kind of things that you have also seen in recent times. So I believe that if at all, the only confusion you may have would be with respect to Article 2. Now, it's actually a very settled principle that the power to acquire or to cede is not provided through any article of the Constitution. And this is exactly what was the reference in the Berubari Union case of 1960, where the Supreme Court explained that especially the power to cede, because that was the question. Berubari Union was a piece of land which was being given to Pakistan, now Bangladesh. So the Supreme Court explained that this power to cede is not from any of the articles. Article 2 is only for integrating an already acquired territory. So to acquire is not a power provided there. To acquire would be a power under the international law of sovereignty. So India, being a sovereign state, inherently has the power to give and take territories. That's what they meant. So it is not covered under Article 2 also. So the correct answer is none of the above. Now, there was another case, I'm sure you know, not the case really. The case was Magan Bhai versus Union of India. Magan Bhai versus Union of India in 1969, where the court also explained that if there is a boundary dispute settlement, boundary dispute, mind the word, the dispute, it is not considered as a cession of territory. It's not giving away of territory. It's just a settlement of dispute. So what had happened at that time, India and Pakistan, they had settled some territory in Run of Kutch. So in the Run area, some territory was given to Pakistan. So case was filed that how can this be done? And ultimately the court explained that for boundary dispute settlement, you don't need to bring a constitutional amendment act or even any ordinary legislation of the parliament. It can just be done by an executive order. Just an executive action is sufficient. So the moral of the story of all this is in three parts you should understand. One, if there is any new territory being added, acquired, or Indian territory being given, there is no dispute. Like land boundary agreement with Bangladesh. Many people get confused and they think that was a dispute between India and Bangladesh. It was not a dispute. It was Indian territory without any dispute that we gave to Bangladesh, and Bangladeshi territory without any dispute, it is Bangladeshi territory, they gave it to India. And so for that, a constitutional amendment act would be required. And for land boundary agreement, the 100th constitutional amendment act was done. Now, whenever there is a boundary dispute settlement, it does not require any legislative process and executive action is sufficient. Whenever there is internal reorganization, let us say creation of Ladakh as a union territory, then it is done under Article 3 of the Constitution, and under that, the provisions of Article 368 will not apply, but in the case of ceding or acquisition of new territory, 368 will apply. So just make sure you understand these things. However, on this question, also the performance was not that satisfactory. Less than 1/3 of the respondents got it correct. Moving on, question number 6. Which of the following words have been added in the preamble of Constitution of India through amendment? Now, this is actually a very straightforward question. Still, slightly to my surprise, again, less than half of the people got it right. I'm sure you know that in the 42nd Amendment Act, 3 words were added: socialist, secular, and integrity. Unity was a word which was already there, so even if you knew that, in the 3 options, the unity is there, so the correct option has to be B. And just to confuse us, you slightly, I did not write purposefully in option 2 one word, secular. But there's nothing I think we need to really discuss here further. By the way, on the right hand side, I'm sure you recognize that the lion capital on the pillar of Ashoka. Question number 7, very pertinent, very important in recent times. The steps to reorganize the state of India, the sequence for that. Now, this is something which I actually expected. A lot of people would be very solid on this issue. However, the performance has been, again, just about 1/4 of the aspirants only. Anyway, I'm sure by now you have revised your Article 3 provisions. If not, please do that. I'll quickly take you through. The first important thing you should know, there must be a bill. It must be recommended by the president. It must be referred to the state for opinion. And so when the president refers the bill to the state for opinion, there may be a time limit, there may not be a time limit. And whatever the state resolution is, it is really not binding on the president. It can still go ahead with the introduction of the bill in the parliament. So the first step is that the president would refer the bill to the state. Then the state will pass pass a resolution on that bill regarding their opinion. They may agree, they may disagree. And once the opinion has been sought, then the president can go ahead with the introduction. And once it is introduced, then the parliament will vote on the bill. Another important thing you should know here, that in case there is some amendment required in the bill, it does not have to go again to the state legislature. Only once initially it has been sent, and that is considered sufficient. So this is the sequence in which it can be done. Let's move on to question number 8. Which of the following statements is correct regarding the parliamentary system of governance? Decently straightforward question, basic principles. Let's see. First statement says head of the state is not elected by the people. Now, it's not necessary that they are not elected. In India, they are elected. But in UK, they are not elected. The head of state is hereditary. And that's the crown of the British Queen as well. So it's actually a wrong statement. Then it says the real executive powers are vested with the Prime Minister. Now, it's not vested with the Prime Minister. I'm sure careful studies would have told you that it is vested with the Council of Ministers. Please never be confused. I see this, a lot of confusion is there, that they think Prime Minister, because of the aura and the media created image, it's not the Prime Minister. The power is vested in the Council of Ministers. Prime Minister, of course, is the head of the council. So this is also wrong. It says there is an upper house in the parliament. This is absolutely not necessary. We have seen in one of the previous questions that upper house is a necessity of a federal system. It's not necessary to have it in the parliamentary system. Now, the British parliamentary system, they do have an upper house for different reasons. It's not a necessity of being parliamentary system. So there are many countries in the world which have a unicameral parliament. Our own neighbor Bangladesh is one example. Other countries like New Zealand and Denmark, Sweden, Norway, and also Israel, which has been in the news for some time, you must have noted. So again, very poor performance. I realized that more the conceptual questions, the performance is actually on the lower side. So also these were initial questions, so I guess that's the reason. But I would recommend that you please solidify your conceptual understanding, because that is what UPSC would like to test in the prelims stage. Anyway, moving on to question number 9. This I think I've already answered earlier, which is correct. When you cede a territory, you definitely need Article 368. When you have acquisition of a foreign territory, then also you need Article 368. So both are these correct statements. Then again, 30% is the performance. Now, this is just to give you an idea of the map which sorted out the complex phenomena that you see here happening between India and Bangladesh. So this is the classic third level of enclave, Tahala Khagrabari, which now has been sorted, of course. So as you can see, this is a territory of India, which is inside a Bangladeshi territory, which is inside the Indian territory, which is again surrounded by this Bangladeshi territory. So it's a territory within a territory within a territory. So that's why it's a third order enclave. It's a very, very interesting, unique situation in the whole world, which was existing. So for various reasons in history. So anyway, all this has been sorted now, and this was done by using Article 368. So you might like to revise your notes on that as well. Now moving on to the next question, question number 10. This is again a question where I felt a lot of people were confused, actually unnecessarily. Which of the following was not a feature of Government of India Act? And I purposely made it only one to be correct. Otherwise, it would have been even more confusing for you. So anyway, the biggest confusion I somehow realized is with the first statement itself, Reserve Bank of India, that it provided for establishment of Reserve Bank of India. Now, see, Reserve Bank of India was created by the RBI Act of 1934. I'm sure we know that from our knowledge of history and economics and polity and everything. So what the Government of India Act 1935 did, it gave the power to Governor General to appoint and also to remove the governors of RBI, but the establishment was done by a separate act. See, I'll quickly take you through the two important Government of India Acts, that is 1919 and 1935. Now, in 1919 Act, there was one Public Service Commission created at the federal level. In 1935 Act, it also provided for provincial PSCs. So they both have a role to play, but the role is very different. The federal court was definitely created by the 1935 Act, and I think this is more from history. You would know that diarchy was introduced in the states in 1919, whereas it was removed from the states and it was introduced in the center in the 1935 Act. This is already a question that they have asked. Please ensure you understand what is diarchy. Diarchy very simply is the rule of two. That means the subjects at a certain level, they are divided into or they are categorized into what is called reserved and transferred subjects, in this case at the central level. So the performance was again less than 1/3. And this gentleman on the right we have is Mr. Osborne Smith. He was the first governor of the Reserve Bank of India. So these were all the questions that I had in this video. In every video, I'll also in the end give you some extra information which is not totally related to polity, but some kind of knowledge for exam and life. So as you know, in the Upanishads, there are a lot of information. So there is something called the Mahavakyas. So in each of the Vedas, there is one Mahavakya that is given. So today I'll leave you with one Mahavakya, and that is in the Rig Veda, Prajnanam Brahma, which means the consciousness is Brahma. So that's all for the first 10 questions. You can see the next video for the question numbers 11 to 20. Thank you.